हेलो फ्रेंड्स, वेलकम बैक टू आवर चैनल। तो आज हम लोग इस वीडियो में बात करने वाले हैं एक ऐसी लीगल मैगज़ीन के बारे में जो चाहे क्लैट का एग्ज़ाम हो या जुडिशरी का एग्ज़ाम हो, इस मैगज़ीन से मोस्टली क्वेश्चंस पूछे जाते हैं। इवन जुडिशियल सर्विस 2018 में भी इस मैगज़ीन से रिलेटेड क्वेश्चंस पूछे गए थे। तो आज हम लोग बात करने वाले हैं नॉसिटर असोसिस के बारे में। व्हाट इज़ द लिटरल मीनिंग ऑफ नॉसिटर असोसिस? द मीनिंग ऑफ अ वर्ड may be known from accompanying words. Means the principle of Noscitur associs is a rule of construction. It is one of the rules of language used by the court to interpret legislation. This means that the meaning of an unclear word or phrase should be determined by the words immediately surrounding it. The eminent Professor Graham illustrated the maxim with an example of inability of an insured bankrupt to collect proceeds in the event of illness, disability or death. Bankruptcy means that there is a disability under the law, since you cannot hold office and considered legally disabled. However, the rule of Noscitur associs says that in spite of this, no one can collect insurance since disability is associated or related by illness or death. In this context, it is clear that the intention of legislature is that disability refers to the physical capacity, as it is clear that this meaning can be determined in reference to the color of other words in this provision. Now, let's move towards the important case laws related to this maxim. The first case law is Commissioner Income Tax versus Bharti Cellular. In this case, it was held that technical service used in section 194J of Income Tax Act is unclear. The word technical would take color from the word managerial and consultancy, between which it is sandwiched. These terms, managerial service and consultancy service, necessarily involve human intervention. So, by applying the principle of Noscitur associs, the word technical would also have to construct it as involving a human element. Thus, interconnection and port access service rendered by the SC do not involve any human interface and therefore cannot be regarded as technical service under section 194 of the Income Tax Act. The second case is Foster versus Diffie Cashin. In this case, it was stated that the statute involved which stated that explosives taken into the mine must be in a care or canister. In the instance case, the defendant used a cloth bag and it was held that by applying the principle of Noscitur associs, the intention of the parliament was of using care or container, means using something of strength of a container. Thus, it was held that the bag does not fall under the statutory definition. अगर आप सभी को वीडियो अच्छा लगा हो तो लाइक करें, कमेंट करें, सब्सक्राइब करें। थैंक यू।